Hi, guys. Welcome to another segment of Legal Friday with me, Francine. So I think today is really an important segment if you have ever thought about collaborating on a creative project with another person. So let's take a look at some things I think you should think about in order to get yourself started. So if you've ever thought about entering into a joint relationship, and I actually want to stress intending to enter into a joint relationship, because that's what the Copyright Act says. It says if two or more parties intend to enter into a joint relationship, then each one of those co-authors is considered a joint owner. Why is that really important? Well, it's important because each of you has an equal ownership interest. Now, you may not think that's a big thing, but believe me, if you have an equal ownership interest in the copyright, and they have an equal ownership interest in the copyright, that means that they can do anything that you can do. Contributing just ideas or just edits don't necessarily rise to that level. If you remember, ideas are not protected by copyright. However, and here's the caveat, if you intend to enter into a relationship with someone else, even if they contributed only a little bit, even if they contributed just an idea and you did all the grunt work, if you intend to enter into a relationship that's joint, then you both have an equal ownership interest in the work. The contributions don't have to be equal. That's the other thing. So let's say, suppose you're writing a book. And let's say you hire someone, or let's say you don't hire them. Let's say you actually enter into a relationship with a collaborator. The collaborator is only contributing one chapter. You, on the other hand, are contributing, let's say, 12 chapters. Doesn't matter that they have one chapter and you contribute 12. If you intend, if the two of you mutually intend to enter into a joint work, then for the purpose of copyright, it's a joint relationship. And unless otherwise agreed to in writing, the interests are going to be divided equally, period. So the bottom line there is, honestly, you should always have it in writing. I mean, always. And that's something I stress constantly on, whether I'm giving a talk on copyright, whether I'm teaching at the law school, whether I'm talking to a client, whether I'm talking to a friend, you should always get it in writing. Why? Because it's easy for us to think one way. One person might say, well, I remember it this way. And the other might say, well, no. I remember it was this way. Unless it's in writing, it becomes a matter of he said, she said, and that becomes really problematic when it comes to the law. In fact, there are so many lawsuits based on, well, you said this, but no, I thought you said that. So you want to get it in writing. So here's a short list of some things I think you should think of before you're entering into a relationship that's collaborative with another person. Number one, you want to make sure, if you intend that it's going to be a joint relationship, that you state that. It needs to be crystal clear. Don't leave it to the imagination. The other thing is, if it's not a joint relationship, or even if it is, what is the collaborator going to contribute? What's going to be their role? So again, for example, if one person is to write a chapter and the other person is to write 12 chapters, okay, but make that clear. Or let's say you're writing a picture book, a children's book. One person's going to create the images, the other person's going to create the copy. Whatever it is, you want to get it in writing. Who's going to own the copyright? Well, again, if it's going to be a joint work, if you are intending that it's going to be a joint work, then you're both going to own the copyright. So that's a no-brainer. That again is why it's so important to make sure, if you intend that it's going to be a joint work, make sure it's in writing. Otherwise, who's going to own the copyright? If it's you, what is the collaborator going to get? Are you going to give them credit? Let's say you hire a ghostwriter to write your book, but you're wanting to be the copyright owner. Okay, you're going to give them credit or not? You don't have to, but whatever you decide, you need to get it in writing. How will the collaborator be paid? Will they be paid a flat fee? Will they be paid royalties? Will you give them licensing rights? Whatever it is, get it in writing. Let's say there are two joint owners. Will you both have equal say in terms of creative control? Or will one person have more control? Will one person have the final say in terms of creativity, like what's going to be on the book cover, what's the format, things of that nature? Will the collaborator receive books? Well, if it's not a joint owner and it's just a collaborator, will you give them books? Will they have to pay for books? Will you give them books at a discount? Whatever it is, again, the key is to get it in writing. This is just a short list of some things I think you should think about before you start entering into a collaborative relationship. Personally, I'm not someone who encourages joint relationships because I think they could get to be pretty messy. But if you make a decision to enter into that kind of relationship with another person, get it in writing. Bottom line. Okay, I'm Francine. This is Legal Friday with me, Francine. Until next week, have a great weekend.